There is an unmistakable facial expression that I see when I meet with adult children who are concerned about their parents. These adult children are often managing their own family obligations and financial responsibilities, while at the same time managing the care needs or the responsibilities of a parent. On top of all of that is a burning question, and I see it on their face. The adult child asks, "Am I responsible for the debts of my parent?" The answer to that question depends on whether the parent has died or whether the parent is still alive and receiving what is often expensive long-term care. Let's start with the situation where the parent has died. My office will sometimes get the call from the adult child who is literally standing in the parking lot of the hospital or the funeral home. The child has a bill of the parents in hand, and the child feels a great deal of urgency to go and pay that bill. I understand why. The adult child is a responsible person. He or she pays bills, pays taxes, does responsible things, and it seems wrong not to immediately pay that bill. There is an order of things, and the general answer is that the adult child is not responsible for the debts of a deceased parent. Here's how it's supposed to play out. First, we gather all of the assets that the deceased parent had when they died. So we're looking at bank accounts, we're looking at credit union accounts. Did the deceased parent have brokerage accounts or retirement accounts? Was there life insurance? Was there real estate? So we're looking at all of the assets of the deceased parent, and yes, we're also looking at debt that we currently know about, but the next step is not paying bills. The next step is that there's a petition filed in the county courthouse. We're asking the court to open an estate. During that process, the executor of the estate will be sworn in to manage the estate. What's the first thing the executor might do after getting sworn in? Well, the executor is going to go and close down accounts of the deceased parent and then open up a new account called an estate account. That's where all the money goes from the closed accounts. So now you have an estate account. It's the money of the deceased parent. That is ultimately where we will pay the debts of the deceased parent, not out of the child's own bank accounts. But wait, we're not paying bills yet. The next thing you do is follow a process to provide notice to all of the creditors of the deceased parent. You might have some bills in hand already, but there are others you don't know about. You provide notice to all the creditors start sending their bills, and the bills get paid out of the estate account. Is this a delayed process? Are we paying bills at a slower pace than what people are generally used to? Yes, we are. But here's the thing. We are no longer concerned about the credit score of the deceased parent. The creditors know that this process must play out before they get paid. It's part of their business model. They know it has to happen. So it's important to know that there is an order of things and to take it deliberately. What would happen if we gather up all of the assets and all of the debts as the first step in the process, and we find out that there's way more debt than there is money or real estate to even cover the debt? That's called an insolvent estate. So back to the child who's calling my office from the parking lot of the funeral home and wants to pay credit card bills. Well, hold on a second. Now with an insolvent estate, that child might be paying a bill that never gets paid at all. They're voluntarily handing over their own money for a creditor who does not get paid because it's an insolvent estate. When there's not enough assets to cover the debts of an estate, Pennsylvania law says you pay back taxes first, then you pay the funeral homes, then you pay the medical debt, and at the end of a long line of creditors are the credit card companies. So when the adult child goes and pays a credit card bill, there might not have been any money in the estate to even pay that bill, and the child is not getting reimbursed. So that's something to be aware of. That's why we follow the order of things. And we don't pay bills right away. We want to know how much is there in assets and then how much is there in debts. We follow the process. We pay the debts using the deceased parent's assets, not the child's money. Are there exceptions to this general rule? Sure, and they are probably obvious to you. If the adult child co-signed a car loan with the parent dies, well, the child is still on the hook, but the child was on the hook to pay off that car loan before the parent passed away. Same thing if the child inherits real estate with a mortgage on it. That loan still has to be paid, and if the child wants to keep the real estate, the mortgage has to continue to be paid by the child. So those are some obvious exceptions to everything I've said. Back to the original question, meeting with that adult child who wants to know, what am I on the hook for personally? What if the parent is still alive and receiving long-term care? Well, that is one situation where there's a chance that the adult child might have to come up with some money, but let's take a deeper dive on this. There are generally 3 levels of care where a parent might just need extra help getting through the day with dressing and bathing, maybe some meal preparation, but they stay in their own home. So maybe a professional home care agency is coming in, and of course they charge a fee. That can be paid out of the parents' bank accounts, that can be paid using long-term care insurance, and there are some public benefits that might pay for home care. Public benefits are veterans benefits or Medicaid. That's a subject for a different video, but all of those payment options are on the table. Could an adult child pay for it? I suppose so, if they want to cover that, but that's a choice, that's not an obligation. If the parent moves up a level of care in Pennsylvania, that's usually a personal care community. Maybe it's memory care. Maybe it's assisted living. Again, that's the parent's bank account being the source of payment for that care. It is possible that veterans benefits might help if the parent is a veteran. There is no Medicaid at that middle level of care. So then when we go to the highest level of care, that's the skilled nursing facility. When I say nursing home, that's what I'm talking about. People use that term interchangeably, but a nursing home is a skilled nursing facility. It's very expensive, but if the parent is receiving that level of care, their own funds could pay for it. Long-term care insurance could pay for it, and now how most people pay for it is Medicaid. Where am I going with all of this on the levels of care? Because one, you want to know there are levels of care. There's no such thing as the home. You want to know that with each of those levels of care, it gets more and more expensive, and so maybe as the adult child, you're getting more and more worried about how to pay for it, but really the only time that the adult child is on the hook has to do with Medicaid in the nursing home setting, the highest level of care. Because among many other picky rules with Medicaid is the so-called 5-year look-back. What does that mean? It means that the state is reviewing a lot of paperwork, a lot of financial statements and tax documents, because in order to be eligible for Medicaid, the person who needs Medicaid to pay the nursing home can't have a whole lot of money left, and there are ways to deal with that. But one thing they're definitely looking for is in the 5-year period before that parent applied for Medicaid to pay the nursing home, was the parent giving money away? Right now, somewhere in Pennsylvania, there are people sitting around a kitchen table. The parent is anticipating a long-term care need. So the parent is deeding real estate over to family members, making payments, writing checks to kids or grandkids. But the problem is the nursing home has to be paid. When that day comes that there's a big bill for care, that parent might not have any money left. So then, if there's no long-term care insurance, you better hope there's Medicaid. But if the parent had been giving things away, giving real estate, giving money away for years before asking Medicaid to pay the bill, Medicaid's going to impose a penalty period. They add up all the gifting and the transfers of real estate, and they compute a period of time that the parent must pay privately before Medicaid will kick in. So if there is no money to pay privately, there is no long-term care insurance, and there's no Medicaid because of all the gifting the parent had done, that is when the children are on the hook. It's the so-called filial responsibility law. Every state has it, but in Pennsylvania, it is a collection tool. So the nursing home is going to tell the adult children, nobody else is paying us, you have to pay us. And if the adult children refuse to or can't, they get sued. So that is not common, but it is the one time when the adult child might have to worry about being on the hook for financial responsibilities of the parent. Hopefully this has been thought-provoking for you, and I guarantee you there's going to be other videos in our channel at Keystone Elder Law that might be relevant to this and might add on to the information. So go look around the channel, subscribe to the Keystone Elder Law channel, and if you're in South Central Pennsylvania, check out KeystoneElderLaw.com or give us a call at 717-697-3223.